Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahi rabbil alamin. Wassalatu wassalamu ala asyrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajma'in. My name is Muhammad Adni bin Muhammad Nasruddin. Metric number 24004459. I am from program Bachelor of Islamic Studies from Academy of Islamic Studies. First of all, for everyone's information, we were all assigned to do a video for explanation about a topic in subject Nazariyatul Hukmi Al-Syara'i fil Usul Fiqh that taught by our respected lecturer, Associate Professor Dr. Muhammad Saiful Anwar bin Muhammad Nawawi. Today, my friend and I will explain about Sabab and Sharat. I hope you all can get benefit from this video and understand about this topic. I would like to share with you about sabab. That's mean cause. First of all, we have to know about the definition on topic today. But for your information, all of this knowledge for this topic I get from book The Principle of Islamic Jurisprudence by Muhammad Hashim Kamali, page 291 and 292. Definition of cause is a sabab is an evident and constant attribute identified by the lawgiver as the cause of a legal ruling, or we call hukum. Its presence means the ruling applies, and its absence means the ruling doesn't apply. Sabab or cause have two types. One, within the mukallaf's control, and second, beyond the mukallaf's control. For example, for within mukallaf's control is like murder. Murder is cause for retaliation, or in Arabic we call qisas. And second example, like theft. It's cause for a had, penalty, or hudud. Next, example for beyond the mukallaf's control is minority. Minority is cause for guardianship over a minor's person and property. When sabab exists, its effect, musabab, occurs automatically. Whether the mukallaf intended it or not. For example, when a man divorces his wife by a reversible talaq, or we call talaq raj'i, the husband has right to resume marital relation even if he denies it. Similarly, when a man enters into a contract marriage, he obligated to provide dower and maintenance for his wife, even he explicitly stipulates otherwise. Last but not least, the effect of sabab is determined by the lawgiver's decree and is not dependent on the mukallaf's intention. And that's all from me about sabab. Now, I pass to my friend for explain about syarat. Assalamualaikum warahmatullahi wabarakatuh.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Najmi Farhan bin Sazali. My metric number is 24004464. Today, I will be explaining an important concept in Islamic jurisprudence known as shart or condition. This concept plays a main role in understanding the framework of Islamic law, especially when it comes to obligations and contracts. I will cover its definitions, types, its role in comparisons with rukun, and give some examples to help you grasp it better. Let's dive in. Definition of shart is defined as an evident and constant attribute whose absence negates the validity of a legal ruling, but whose presence doesn't necessarily bring about the ruling. For instance, a valid marriage is a precondition for divorce. However, this doesn't mean that every valid marriage will lead to divorce. Similarly, with wudu is a necessary for salah, but having wudu does not mean that you must do salah immediately. Okay, now how shart complements a cause or illah. A condition often complements the cause is illah and ensures that the cause achieves its intended effect. For example, killing someone is the cause of qisas, but this is conditional on the act being deliberate and hostile. In a marriage, the contract is the legal cause for allowing marital relationship. However, the full effect of the contract depends on fulfilling other conditions, such as the presence of two witnesses. Thus, the absence of a shart makes the ruling invalid, even if the cause exists. Without fulfilling all necessary conditions, the law cannot be applied in its entirety. Okay, now I want to explain about two types of shart. Okay, these are two main types of shart. The first one is syarat syar'i. Syarat syar'i is these are condition set by the lawgiver, meaning Allah Subhanahu Wa Taala and His Prophet Muhammad Sallallahu Alaihi Wasallam. Okay, for example, for syarat syar'i is the requirement of witnesses in a marriage contract. Is two witnesses in a marriage contract. Okay, now we move to the second one is syarat ja'li. These are conditions stipulated by the individuals involved, known as the mukallaf. For instance, a couple may stipulate in their marriage contract that they will reside in specific locality. Okay, this distinction help us understand that some conditions are universal, while others can be tailored based on the agreement of the parties involved, as long as they do not contradict Islamic principles. Okay, now we want to see what the difference between syarat and rukun. Okay, the between syarat and rukun or essential requirements is a rukun is an element that forms the essence of a ruling or act. Without it, the ruling or act collapses entirely. For example, rukuk and sujud are pillars of salah. Without this, the prayer becomes invalid. A shart, on the other hand, is external for the essence of the act but complements it. For example, wudu is a condition for salah, while it is necessary for the validity of the prayer. It is not part of the prayer itself. Okay. To summarize, the absence of a rukun nullifies the entire act, while the absence of shart prevents the act from being validly performed. Okay, now we see two real life scenarios in our situation. Okay, in fasting during Ramadan, the intention, or we call niyah in Arabic, before dam is a shart. Without it, the fast is invalid. However, the intention itself is not part of fasting, like abstaining from food and drink is. For contrast, like says, the consent of both parties is a condition. Without mutual agreement, the contract is void. These examples show how Sharat ensures proper adherence to the law without being a core component of the act itself. Okay. So why understanding Sharat is important? Understanding Sharat is essential for anyone studying Islamic law because it helps us distinguish between what is foundational and what is complementary. This distinction allows us to, first one is identify why certain actions may be invalid. Second one, ensure that all necessary conditions are met before applying a legal ruling. And the last one is recognize the flexibility Islam provides in setting conditions for contracts and obligations. Whether it's act of worship, contracts, or legal rulings, Sharat plays a vital role in ensuring order and clarity in Islamic jurisprudence. In conclusion, Sharat is a fundamental concept that supports the validity of legal rulings and acts in Islamic law by distinguishing between Sharat and hukum. We can better understand the requirements of worship, contracts, and laws. I hope this explanation has clarified the concept for you and provide useful insights into how Islamic jurisprudence is structured. Okay. Jazakumullahu khairul jazak. Wabillahi taufiq wa hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. And hi, my name is Ahmad Mujahid bin Hisham. My matrix number 24004463. First of all, today I would like to talk about conclusion from both texts. In Islamic law, Sabab and Sharat are important concepts related to the applicability of ruling hukum. 1. Sabab. Sabab is a clear and constant attribute or action that serves as the cause for the applicability of ruling. The existence of sabab directly leads to the existence of the hukum, while its absence causes the hukum to be absent as well. Sabab can be within the control of the mukallaf, such as a murder of theft, or beyond the control of the mukallaf, such as the status of being a minor. The effect of the hukum automatically occurs when the sabab exists, regardless of the intention of the mukallaf. 2. Sharat. Sharat is a condition or attribute whose absence causes the absence of the hukum, but its presence does not necessarily lead to the implementation of the hukum. Sharat complements the sabab and ensures the full effect of the hukum. For example, ablution wudu is a condition for prayer salat, but the presence of the wudu does not necessarily lead to performing salah. Sharat can be stipulated by the lawgiver, syarat syar'i, or by the mukallaf, syarat jali, and it serves as a complement to the hukum, rather than being part of its essence. 3. Differences between sabab and sharat. Sabab directly causes the applicability of the hukum, while syarat only complements the sabab and ensures the hukum is enforceable. Sharat differs from rukun because a rukun is an essential element that is part of the essence of the hukum, whereas sharat is merely a prerequisite that complements it. Overall, sabab and sharat are fundamental elements in the structure of Islamic law. Sabab acts as the trigger for a hukum, while sharat ensures the hukum is valid and complete. Understanding both concepts helps to clarify how Islamic rulings are applied and executed. That's all from me. Thank you for listening. Assalamualaikum.